we're all here because there were some nasty things done during an election and things that I feel are not defensible. And if the city has played a part in any of that, I think that needs to be revealed.
The initial response for just the names of 3 individuals named in the subpoena is 17,700 plus emails.
Your games are costing the city money. At the bottom line, you can look at me all smirky all you want to. It doesn't bother me one little bit. But your games are costing the city money.
We have 2 attorneys already on staff, and you have a fair number of people can find records. I also believe finding records is not as complex as it is trying to be very careful of what you give out from those records. So perhaps maybe we could save some money and just give what we should give. As a resident, I really object to doing that. Maybe the mayor would like to donate his salary to this cause. That would be a use.
I say, just answer the subpoenas. Give them all the information between the dates they want and let them pay their attorney to sort it out. And permit Mr. Broom to earn his $207,147.20 salary for last year by releasing public documents to their attorney.
The idea that the city needs to retain a criminal attorney to respond to a simple subpoena for public records, which is no different than a FOIA request, is insane. The city council may be concerned about what it discloses with regard to council members themselves or city staff or city employees. But I agree with Member Moscoso, and we should not be circling the wagons to cover our behinds. We should be disclosing the facts and let the facts fall where they will.
Could you explain the situation that led to a subpoena, kind of the backstory to why we have this special meeting, what we're talking about here?
Received a subpoena for records.
Do you know anything about the case?
No, I do not.
17,700 plus emails.
This is the state of Florida versus Vicki Conklin. There's no lawsuit against the city of Titusville. In my opinion, it looks like we're just providing records, and it sounds like we need additional staff. I'm not sure we're at the point that we need to be spending taxpayer dollars to hire an outside attorney. These are taxpayer dollars, and so I am very wary. I think we need to be extra careful on this.
Member Moscoso?
No.
Member Nelson?
Yes.
Vice Mayor Cole?
Yes.
Member Stokel?
Yes.
Mayor Connors?
Abstain. I'm a victim in this case, and I feel that my judgment should not be compromised.
When we've received subpoenas in the past, do we typically ask them to narrow the scope?
Yes, there are times when we ask someone whether or not they want to, and typically if it's a rather large request, if you could give us a time, a subject matter, the clerk then could scope those words and really provide those records that they're really looking for.
To clarify, we have asked this attorney to see if they could narrow the scope?
I did. I think Chelsea spoke with them and understand if they need records for their case and that's what they want. But yeah, we did reach out, but we
did already ask to narrow it?
Yeah, but we were unsuccessful in trying to say how that would be narrowed or getting a time extension.
To clarify, we have asked for an extension, and we did ask to potentially narrow, and we were told no on both.
I'll have to defer to Chelsea. She's working on it.
Okay.
Yeah, we originally reached out to Mr. Robinson by phone, and he requested that everything be put in writing. So I sent him a detailed email asking for the scope to be narrowed, the dates of the time frame within the subpoena to be narrowed, and or for an extension of time for our response. And we received a no on all accounts.
It's still early. We've only had this it's been 10 days. Could work with this firm maybe in scaling it down.
As I understand, the state attorney did not object to the subpoena per the rules. Is that correct?
That'd be my understanding, because when you do a third-party subpoena of this nature, like in a civil, in that arena, you first send it to the other party and see if they have objections, and they have so many days to object. And if they don't object, then you forward it.
It says Come now, the defendant, Vicky Joyce Conklin, by and through the undersigned attorney, and files a certificate that no timely objections have been received from any party to the notice of intent to serve subpoenas to the city, to the Titusville Police Department and the city of Titusville. What does the no timely objections?
Correct, that would be when you send it to a party, as we said before, in this case, they send it to the state attorney's office. They have, under the rules, I have in front of me, a period of time to object. And if there's no objection, then they forward it to us. That's what I was saying before. So they forwarded it up to us saying they received no timely objection.
So the state attorney is saying, I'm
He
sorry
is
if I.
saying the state attorney did not object.
The city is a non-party, so we did not receive a notice prior to getting the subpoena that we could have objected to. And I don't know if there's any rules or processes out there that speak to whether or not third parties should receive notice prior to receiving that subpoena, but that is a procedural thing that we would like to consult with our additional counsel that may be more proficient in that area of law.
What I'm struggling with is the reason that we're in this situation. If I can be honest, it's not for a good reason. We're all here because there were some nasty things done during an election and things that I feel are not defensible. And if the city has played a part in any of that, I think that needs to be revealed. And so, yes, I want the city to be legally protected. However, what I saw was not good. What I saw when Mayor Connors put up signs of his opponent was not good. What I saw the chief of police put out a video and because of state statute had to take it out was not good.
We met with a mayoral candidate, Vicky Conklin, here at the Titusville Police Department.
So I am all for these records being presented. And I think, Mr. Broom, I talked to you about this, and I asked you, when that video came out from Chief Lau, what were the repercussions? Why did it get taken down? What did you do about it? Now that information is now going to be sent to this attorney. How do we defend this? Do we spend more taxpayer dollars, or should we have handled this internally? So there, for me, it is a kind of a background to it of the frustration. Member Stokel, you were out there, you saw the signs. You know, we can just go in circles around this, but this is more than just producing records. Just got this on my desk, but this has a little sticky note, which probably was not supposed to be there. And it says phone numbers to be searched, which emails to be searched. BCSO asked them, SAO asked them, SO2 asked them, Andrew can't search his.
Sure, that sounds like,
What does that can't search his mean?
Can I see it? It's my handwriting.
Yeah. It was on my desk.
right, that's one of the other requests. From what you're saying, sounds like with regard to, there was a request for phone logs, and we weren't sure how to,
I'd like to have that back if possible. Thank you.
it was phone logs. And how do we, and I'll let Chelsea speak to that because that's her notes, but I think that was in relation to the phone logs.
A subpoena for confirmation for everyone listening to any confusion you may have says that the city is demanded to respond to copies of a whole list of things, including phone logs about Vicky Conklin created, and then it continues, phone logs about Earl Johnson, phone logs about Andrew Connors, and then it goes on, trying to find.
Sorry, I'm specifically asking about the sticky note that's on top.
Right, and I was making notes from the subpoena into my sticky note, and when it says Andrew, and I wrote can't search his, I can't search his personal email. That's what that note means, and so I wanted to explain what my notes were that weren't meant to be shared with you tonight, and I apologize for this confusion. I don't know how it ended up on your desk.